Bom dia a todos, meu nome é Leonardo Nemer Caldeira Brant, eu presido o Centro de Direito Internacional com sede em Belo Horizonte. É com muita alegria que eu saúdo a todos os presentes, saúdo igualmente os professores internacionais e nacionais que irão estar conosco durante essas 2 semanas, durante o 16º curso de Direito Internacional. Eu gostaria de dizer que, em primeiro lugar, esse curso foi todo desenhado num novo modelo online. Nós já estamos aí no 16º curso desse gênero. Ele foi totalmente adaptado às novas circunstâncias, o que, de certa forma, permitiu também uma extensão do número de participantes, de professores internacionais e nacionais participantes. Temos este ano 19 grandes nomes do direito internacional que estarão presentes conosco durante essas 2 semanas. Num primeiro momento, portanto, eu gostaria de agradecer a todos os professores que colaboraram conosco, que estarão conosco nesse período, com palestras muito interessantes sobre temas dos mais variados do direito internacional. A todos eles, o meu muito obrigado. Em segundo lugar, saúdo e agradeço também aos alunos, aos estudantes que estão participando neste período de julho, conosco durante essas 2 semanas. O nosso também muito obrigado. Esse é um curso que envolve uma grande equipe do Centro de Direito Internacional, a qual eu tenho o imenso orgulho de colaborar e de presidir. Ele é um curso que pretende trazer para o Brasil e para a nossa América Latina o mesmo modelo de cursos que, de forma quase centenária, já é uma tradição nos países europeus e nas principais universidades do mundo. Portanto, para nós, uma grande satisfação que tenhamos ele já há mais de uma década no Brasil. O curso de inverno de Direito Internacional, com toda a sua abrangência e extensão, não seria possível de ser realizado igualmente se não fosse a relevante parceria e a confiança e o apoio da Fundação Konrad Adenauer no Brasil. A ela estendo um caloroso agradecimento e tenho a certeza de que estamos contribuindo juntos para os valores do direito internacional, para os valores dos direitos humanos, para os valores do Estado Democrático de Direito, para os valores da democracia e, com certeza, para a compreensão e construção de um mundo, de um universo internacional mais justo e mais equilibrado. Portanto, agradeço de forma calorosa ao apoio da Fundação Konrad Adenauer no Brasil. Gostaria, portanto, de dar início ao 16º curso de inverno de Direito Internacional, esperando que todos tenhamos 2 semanas de muitas atividades e aprendizado. Um forte abraço a todos.
Good morning, dear colleagues and students. May I have your attention, please? First of all, I would like to welcome you all to this virtual lecture about the International Court of Justice and Human Rights. My name is André de Carvalho Ramos. I'm a professor of international law and human rights at the University of São Paulo Law School, and I will be your moderator. Today, we are honored to have a lecture from Professor Bruno Simma. Before the presentation begins, allow me to introduce our lecturer. Bruno Simma is professor at the University of Michigan Law School, and he is a retired professor at the University of Munich. Also, he served as a judge on the International Court of Justice from 2003 to 2012, and currently is arbitrator on the United States Claims Tribunal. In the past, he was a member of the UN International Law Commission and also a member of the Committee on Economic, Social, and Cultural Rights. Professor Simma has more than 120 publications. Among them, I can mention the Charter of the United Nations, a commentary from Oxford University Press. I would like to thank Professor Leonardo Nemer and all of the CEDIM team on behalf of Paula Neves for the organization of this exceptional seminar. Finally, the organization asked me to inform that the session of question and answers will be made only tomorrow, after the presentation of the final part of the lecture. Without further delay, I'd like to welcome our lecturer to deliver his presentation. Thank you again, Professor Simma. The floor is yours.
Well, thank you very much. Thank you and Professor Brandt in Belo Horizonte for this invitation. Just before we started, I remembered that I was in Belo Horizonte for a week in 2005, and I had a wonderful week with about 300 students, but also with a football game in that huge football stadium of Belo Horizonte and the steaks and all that. So I have a very, very fond memory. I don't even remember what I taught, what course I taught in Belo Horizonte, but I hope it wasn't what I'm going to tell you tomorrow, or today and tomorrow. Professor Alain Pelé, who is also going to be among the teachers in this course, once wrote a paper on droit de l'hommisme, the human rightism, which he considers as a pain in the neck, people that have lost touch with reality, people who are wishful thinkers. And then he counted a number of names. And I was among these names, but at least he kind of modified his judgment a bit by saying that Bruno Simma is a reasonable droit de l'hommiste. And I think that is a good description of what I am, because I really distinguish between my professional life and my private life. In my private life, of course, I fight for human rights when there is a chance. I help and assist. In the academic scene, I'm not a fighter. On the academic side, I'm more an observer, somebody who likes to look at the situation in which human rights and the general community, let's say international law, the traditional international law, meet and interact, and what kind of reactions this process shows. So I'm in a very different category from the human rights lawyers like your fellow Brazilian Cansado Trindade, who is a good friend of mine, but he's also a fighter and in his writings, and I'm more the guy who sits on the side and looks what happened. And so I'm going to tell you about my experiences with human rights and my impression of how human rights fare at the International Court of Justice. My interest in human rights was, let's say, I didn't start out as a human rights lawyer. I started out as a very bread and butter public international lawyer, more interested in sources, the law of treaties and stuff like that. But then in the mid-1980s, I was appointed to a new UN human rights treaty body, namely the UN Committee on Economic, Social and Cultural Rights. And what I remember, and I spent 10 years with that committee, and what I remember is that I always felt a bit on the sideline as an international lawyer, because this committee consisted of economists, political scientists, a few lawyers, and a number of people whose origins and whose, let's say, I could never get a clear picture of. And sometimes I felt in that committee that I had to protect international law against the human rights people. And then in the early 1990s, I changed from the human rights body to the International Law Commission. And my experience there was about 180-degree different. In the International Law Commission, I felt I had to protect human rights against the international lawyers there. Let's say the mainstream international lawyers in the International Law Commission, like former legal advisors or domestic judges, people like that, who had very diverse and, in my view, very problematic opinions on human rights. And so one of the things I managed in the International Law Commission was to keep the International Law Commission from taking up human rights topics during the time I was in the Commission. And I think the Commission has not really done much human rights work since then either. And then in 2003, I was elected to the International Court of Justice. And so I was very interested to see how would human rights be handled there. My plan for these two lectures is as follows. Today, I'll start with a very brief facts about the International Court of Justice from the viewpoint of my lecture. That is, what are the features of the ICJ which are of relevance to the ICJ's dealing with human rights? Then I'm going to give a very short introduction also about what I understand by international human rights, the international human rights system. And then I'll turn to the essence of my lecture, which is, of course, the ICJ and human rights. And there I'm going to divide this part of the lecture up into two chapters. The first chapters will consist of a tour d'horizon of the jurisprudence of the ICJ relevant to human rights, culminating in some extremely interesting cases decided in recent years. And I will conclude tomorrow by looking at the legal or political context or limitations for the ICJ in human rights matters. And of course, end with the usual prospects for the future. All right. So first, a few basic facts about the ICJ. I remember that Professor Brandt published or edited a huge book about the International Court of Justice in Portuguese. And I'm sure that in your classes you probably heard more about the ICJ than you wanted to hear. But just a few facts. What is very important to remember is the ICJ is an old court. It's now about 90 years, more than almost 100 years old. And this shows in many provisions of its statute and in the way it works. Of all the international courts around, it is the court that has most features of arbitration, that is, features of arbitration, and in that regard is a bit old-fashioned. Of course, you know that the ICJ cannot decide contentious cases without the parties having given their consent. And in many instances, in many cases, years will pass before the ICJ has made a decision whether it does have jurisdiction or not. So consent is at the very basis. And that, of course, is a huge difference compared to courts like the ones I know because I'm closer to them, like the European Court of Human Rights or the European Court of Justice of the European Community at the regional level. So consent is the basis. The states have to accept the jurisdiction of the court in a number of ways. If a state does not have a judge of its nationality on the bench, and of course no state has quote unquote a member on the bench because the judges are independent, of course. But if there is no national of yours on the bench and you are a party to a case, you can appoint a judge ad hoc. I think Professor Candidato Dandaje was actually a judge ad hoc in a case, I think, right until he was appointed to the court. That, of course, is also an element that we know from arbitration, where the entire composition of the adjudicating body is in the hands of the parties. My impression of the ICJ was it's more a civil court. That is a court dealing with civil matters. The entire way it works is a mix of the continental Germanic legal tradition with the common law tradition. I would say, for the taste of common lawyers, a bit too much on the civil side. But the very important positive element is that, of course, this is the only international court in the world which we can, if jurisdiction is given, deal with any question of international law. And of course, among these questions of international law, there are not just boundary questions, maritime delimitations, but also human rights questions. And to these I will now turn. But first, just to give you a few impressions about when we are talking about the ICJ and human rights. So what do I mean when I speak of human rights or international human rights? I have a very unphilosophical, very technical understanding of the matter. By international human rights, I understand the sum total of international legal norms, obligations to protect and respect human rights, obligations which derive both from international treaties, also from customary law. It's a body of international law in which the so-called soft law also plays a very important role. And secondly, I understand by international human rights also the institutions and the procedures by which these institutions deal with human rights by administering human rights topics, implementing human rights decisions, enforcing these obligations. And I'm not by coincidence mentioning enforcing at the very end, because genuine enforcement of human rights is still a very, very, let's say, underdeveloped element of international human rights. But the regime has grown into an impressive edifice, consists now of several dozens of multilateral conventions, many of them having supervisory bodies, the so-called treaty bodies. And we could, let's say, phrase or take as the name for this system, this is the treaty-based system, At the United Nations level, you also have what I would call the charter-based system. When you look at the United Nations, you see there is the Human Rights, the Council, and then around the Human Rights Council, which is like a beehive of institutions and persons, human rights rapporteurs, etc., dozens and dozens of people engaging in I would say, supervision and development of human rights by way of soft law instruments, by way of soft law pronouncements and the like. The entire system has been described in very, let's say, graphic terms by a good friend of mine who is actually not among us anymore, Professor Antonio Cassese. And I'm going to read what he says about this thing. He says, human rights operate as a potent leaven, contributing to shift the world community from a reciprocity-based bundle of legal relations geared to the private pursuit of self-interest and ultimately blind to collective needs, to a community hinging on a core of fundamental values, strengthened by the emergence of community obligations and community rights and the gradual shaping of public interests. I think that is a very good description. In my view, human rights, international human rights, are a revolutionary phenomenon in international law, and at the same time a inherently paradoxical or contradictory element. What do I mean by that? First, human rights are a revolutionary phenomenon. Until a few decades, don't forget, until a few decades ago, international legal concerned of states, if they had concerns in that regard at all, relating to the treatment of their own nationals abroad, was the only thing that counted. States, with regard to what kind of protection, what kind of concern did states have about, let's say, individuals, was the concern of nation states about their nationals abroad. But the treatment of states by a state of its own nationals belonged to the very core of domestic jurisdiction, shielded by international law against foreign intervention. For instance, in the 1930s, there were observers observing the surgence of the, let's say, violent anti-Semitism and other violent developments in the Third Reich in Germany. But among the international lawyers, there was a consensus that the law did not provide for any, let's say, tool to combat this development. The law came in once foreigners were involved. But with regard to the Adolf Hitler and his regime treated the Germans, and among them the German youth, was not the concern of international law. And states in that regard were like what the sociologists call black boxes. You saw the state, the diplomats popped out, the heads of state popped out, armed forces, etc. But what went on within the state was not the subject of a legitimate inquiry by other states. Now, this has really changed fundamentally. And today, the treatment of human beings by public authority has become the subject of international concern. I actually like the term international concern because it's more realistic than speaking of international protection. If you look around the world, if you read the newspapers, you see there's a lot of concern around. But if states, the step from concern to protection is a very difficult one. Just to give you one example, think of Hong Kong, think of the Chinese steps towards the, let's say, cutting the autonomy of Hong Kong, and see how difficult it is for other states to do something, let's say, of weight, of effect against these movements. Now, this international concern has led to what the lawyers call a droit de regard, that is a right for other states to deal with human rights developments in other countries by, for instance, discussing matters in international fora, by what at the UN is called naming and shaming of human rights violations, by what in the United Nations, where everything is very diplomatic and very soft, is called constructive dialogue, in treaty bodies where states present reports. These reports are discussed, and then expert bodies give their advice. What have you done well? What could you do better? So-called constructive dialogue. Then, of course, you have also binding decisions by international courts, like your great court in San Jose de Costa Rica, or the Strasbourg Court on Human Rights. But the real enforcement of sanctions are still more the exception than the rule. But what you, just to, let's say in one sentence what I mean by the revolutionary character of the human rights movement, I think you can say this movement has turned the states insides out. That I find a very graphic, but very, let's say, telling description. The international human rights law and movement is turning the states inside out. Now, I don't know what kind of families you come from, what kind of relations you have with your partners, etc. But you would agree with me that if the insides of your relationships are turned outside, you might get into a defensive mode, and you might not like it at all. And that is precisely what also happens with states. Every state, let's say, proclaims that it is in favor of human rights, that of course it is the mother of human rights, as France says, etc., etc. But there is a lot of resistance also. That gets me to the second point, that is, the international human rights are at the same time something inherently paradoxical or contradictory. Because despite all the international movements, the realization of human rights is still a profoundly national or domestic issue. Ultimately, and that might be of quite relevance to many of you when they think of their own environment, of their own state. Ultimately, only the people whose human rights are at stake can force the elites, the regimes, the government to respect them. If human rights are not part of the political culture of a society, they will have a very, very hard time, and they will be on very, very weak, let's say, ground. So, for instance, and that, of course, is a topic on which I could on, but I don't have the time. But what is a fact is that international supervision, all the things, the treaty bodies, the Human Rights Council, the ICJ, all these international institutions and bodies can only, I would call it, check, reinforce, strengthen, encourage, or harmonize ways and means of securing domestic respect for human rights. And because I think this is so important, I asked Paolo to send you a picture. I hope you have received it. One of the things I love is ships. I love ships. And in my office in my apartment in The Hague, I have this photograph that you should have gotten. I have it over my let's say on the wall. The supertanker. You see a huge bow of a ship, and you see that little tugboat trying to move that bow. You have these tankers nowadays, or let's say bulk carriers that are up to 400 meters long, 60 meters wide, and have a depth of maybe up to about 30 meters. I live in The Hague, and one of my favorite, let's say, little excursions is to go to Hoek van Holland, where you can see all the ships going in and out of Rotterdam harbor. And you look over this, and you see there is a place there where ships bring ore, that is iron, from Brazil. And these ships can only stop and unload their cargo. They can load their cargo in one place in Brazil, and they can unload it. The only place in the world where they can unload it is Rotterdam, because the depth of the seabed there has to be about 30 meters. The ships are so huge. Now, if such a ship, I have to move from ships back to human rights, I'm sorry. But if such a ship is to stop, it takes about 15 to 20 minutes for a ship to simply stop. That's where, for instance, in these international waterways like the English Channel, etc., ship maritime traffic is so dangerous. And I think this is a good paradigm for, you have the sovereign states like the supertankers. They are moving, they have their course, they have their, let's say, targets to go, their places to go. And it will take a huge effort, if any, for these ships to change their course. Take that as a paradigm for international system of human rights concern and the sovereign states. Because the sovereign states are not only them, of course, they produce human rights law, they conclude the treaties, but at the same time, they are also the ones that we look at least at the international legal discourse as the subjects whose activities are of concern to us. And you could say, so governments are at the same time the makers, but also the breakers of human rights. And for most countries, if not all countries, international concern for human rights in one's country is a permanent, to say the least, nuisance, up at the other end to a threat. And you can see in the behavior, in the foreign policy behavior of a number of states, you can see how they react to these threats. I think that's what I'm going to say about what I have to say, just as a mini introduction to international human rights. And with that, I'm going to turn to the ICJ, and it's what in the field of human rights. And here, I think two questions come up. First, has the development of international human rights has had an impact on the jurisprudence of the ICJ? And then you turn the question around and you can ask, has the jurisprudence of the ICJ had an impact on the development of human rights? And these are the two questions that I'm going to deal with for the rest of today and for tomorrow. And Well, I've written a few papers about that, and I hope you haven't read them. Well, I mean, I hope, of course, that you have read them, as any professor. But so that what I'm going to say is not just a repetition of what I have written. In my papers, I have distinguished between two phases in the engagement of the ICJ with human rights. There's a first phase, which is a phase in which the ICJ displays a considerable restraint on dealing with the matter. And then there is a second phase in which the court shows a greater degree of readiness to take up human rights questions and decide them as you expect of a court. And I have to explain that this is not just the term phase is not just there's not just an element of time there, because it would be difficult to say from 1945 to 1970 the ICJ hardly said anything, and from then on it said more. It's more difficult than that. There's a weak, let's say, limb, and there is a stronger limb in the jurisprudence. And of course, the weak limb is fortunately more a thing of the past than the strong limb. But just to make clear that when I speak of phases, it's not just from year X to year Y. Okay, now let me just say a few things about the human rights in the first phase, in which the jurisprudence showed hesitation and restraint. When the ICJ was, let's say, built into the United Nations Charter system in 1945, and then in the first years of the UN Human Rights Commission, one of the topics was, what role should the ICJ play in this new human rights movement? And the British, it's very interesting, the British put forward in about 1946 or 1947 the idea, well, why not, let's say, bring questions, the difficult questions on human rights before the ICJ, and the ICJ could then, let's say, give its view on these questions by way of advisory opinions. And one observer said this was discussed and more or less cut into small pieces. So there was no enthusiasm about the ICJ, having the ICJ involved in this business. Why? And I think the main reason is that in the period of the Permanent Court of International Justice, between the early 1920s and World War II, the ICJ had displayed or had favored, or let's say applied, a very etatist, a very statist image of international law, had put a lot of emphasis on sovereignty. And so the expectation was, now that this new movement, which is directed against protecting individuals against their sovereign or sovereign action, what are we to expect of the court, who has always held sovereignty so high? And so the expectation was very low. But then there are a few little blinks in the early jurisprudence of the ICJ, which show that at least the people did not all share that view or want to continue that outlook at international law. For instance, I think which was the second case, the Corfu Channel case, Corfu Channel, one of my favorite cases, because again, it deals with ships, it deals with warships. The story was that Albania was accused of not having swept from its territorial waters, particularly the Corfu Channel, an international waterway between the Albanian coast and the island of Corfu. So there were still mines around from World War II, and a ship had hit these mines, and so the British sent a number of warships into the Corfu Channel and swept these mines by force, so at least by the threat of force. So this was very much for people like me, warships, blah, blah, blah. But in the middle of the decision, you find the ICJ saying, listen, every state is under an obligation to see to it that other states are not harmed by activities of that state, or are not harmed by a lack or a negligence that state, because there are obligations, and I quote, based on certain general and well-recognized principles, among them elementary considerations of humanity. So, I mean, this statement sits a bit like what the geologists call an erratic block in their judgment, but still it has its place. And I would not be surprised if it could have been at the idea or the great Latin American judge Alvarez, I think, at that time, for that sentence to end up in their judgment. Or then comes the next case I want to mention here is Barcelona Traction. Barcelona Traction, which is about the treatment of a foreign company which was in charge of electricity, etc., supply in Barcelona, and which was lost, which became the victim of one of the great crooks in the Catalonian, let's say, economy and history, and lost its property there. It was its property, and so a case was brought against Spain on Spain's treatment of the Barcelona Traction Light and Power Company. And this is a case which deals with if there is a company, a shares company, and the shares belong to nationals of one state, etc., who has the power to protect that company diplomatically? Is it the state, the home state of the company, where the company was incorporated, or is it the home state of the majority of shareholders? That means something very technical, pure international economic law. And then suddenly, at a very early stage in the judgment, you come across a statement which says, okay, these are bilateral obligations between states. They run between Spain and, let's say, the home state of shareholders. And from these obligations have to be distinguished so-called obligations erga omnes, And then I quote, such obligations derive, for example, in contemporary international law from the outlawing of genocide, as also from the principles and rules concerning the basic rights of the human person, including protection from slavery and racial discrimination. And then full stop. And the rest of the case, a very long case, continues with questions of international economic law and no mentioning of human rights anymore. And you just wonder, how did that sentence get into their judgment? And I remember late 1980s, I invited one of the very prominent judges of the ICJ at the time, Manfred Lux from Poland, for a lecture in Munich. And Judge Manfred Lux did something which I'm not going to do in the course of my lecture, that is, tell stories which had to do with the inner life of the court and how decisions were made. But he very proudly said, who do you think was responsible for getting that statement into the Barcelona Traction case? It was me, said Judge Lux. But of course, at the time, he had a political reason to do that. The judgment Barcelona Traction came out in 1970. And 4 years before, the ICJ had rendered a judgment in a case which was as politically incorrect, quote unquote, as you could be at the time, namely a case concerning Southwest Africa, which was, of course, let's say, a theater of war between the majority of the United Nations members and South Africa for many years. And in the Southwest Africa judgment, the court said, okay, there have been this these two African states, Ethiopia and Liberia, who brought a case, a contentious case, claiming that the apartheid politics in Southwest Africa was in breach of the mandate system, but the court said individual member states that had already been around in the mandate system do not have the right to claim that breach. Only the League of Nations would have that right, and of course the League of Nations wasn't around anymore in 1966. I remember I attended the Hague Academy of International Law for the first time in 1967, and I still remember the rumor, or just more or less, it was almost an outcry among the people there. What shame on the ICJ! And I remember that I was told that all employees of the United Nations, everybody had gotten a pay raise at the time, except the judges at the International Court of Justice. So there was a lot of, let's say, impatience and ire vis-a-vis the ICJ, and so Lux took the opportunity and showed in Barcelona Traction, well, there are some of us who think differently and who have a respect for human rights, and coined that phrase, obligations are gone, as to which I will return. Then in 1981, for instance, you have the Tehran case, the United Nations on the treatment of United States diplomats and consular personnel. In Tehran, they had been taken hostages by the mullahs in Iran after the Shah had fled from the countries. Also very highly political. But what the ICJ says at some point, that hostage taking is incompatible with the fundamental principles enunciated in the Universal Declaration of Human Rights. So that much on that first group. That is, the ICJ mentions human rights, but it's really in a you could say an incidental way. Not much is made out of that statement. The statements are like little fires. They blink, but they are out again. Now, there is a second early cluster of human rights considerations in the jurisprudence that I'm also going to mention. And these would be early cases, let's say relatively early cases, in which the court deals with quite technical questions, really very technical questions, but these questions arise from or are linked to human rights situations or problems. So the court engages in a discussion of a matter which is very different from human rights proper, even though the subject might somehow be linked to human rights. And a case that probably many of you will know in that regard would be the case or the opinion, it's an advisory opinion, on the reservations to the Genocide Convention, which was the first human rights treaty adopted by the United Nations in 1948. And it provides for the jurisdiction of the ICJ, and we will get to these cases in quite soon. But at that time, this was also the time when the Cold War broke out, and a number of European countries, Eastern Middle European countries, became communist. And all these countries, Soviet Union plus the entire, let's say, group of followers, made reservations and excluded the jurisdiction of the ICJ, And this was, of course, countered by the Western countries under the leadership of some Latin Americans, actually. And they brought the General Assembly to ask the ICJ for an advisory opinion on reservations to the Genocide Convention. And if you read the opinion, of course, it deals with human rights. It hinges on the Genocide Convention, but what it then goes out to say is more on how are we going to deal with reservations now that we have more multilateral conventions than we had in the League of Nations period? How are we going to deal with reservations to treaties that have a lawmaking function. The emphasis now should be more on universality instead of consent by all other members to a reservation and the like. So that's what I mean. A couple of years later, actually not a couple of years later, on a year beforehand, you had another advisory opinion on the interpretation of peace treaties with Bulgaria, Hungary, and Romania, where the question, you had these peace treaties, they looked very nice and had and provided for protection of human rights, and also provided for, let's say, the possibility to bring complaints in case of violations. But then, of course, Bulgaria, Hungary, and Romania had turned into communist states, dominated under the, let's say, umbrella of the Soviet Union. And that meant the end for that protection system. And so some Western countries, the United Nations, brought the question before the ICJ, whether you could do a little less benevolent violence to the provisions on that protection. And the court said, unfortunately not. Unfortunately not. If a provision provides that it can only be used with the consent of the states, and there is no consent, that's the end of it. Even in the Nicaragua judgment of 1986, the big Nicaragua judgment, human rights are mentioned in connection with the use of force, because the ICJ tells, particularly the United States, that the enforcement of human rights by the use of force is not an appropriate method. Just a sentence. And then you have in the late 80s and in the 90s, you have a couple of advisory opinions which had to do with the immunities of UN special rapporteurs on human rights, so-called Matsilu and Kumaraswamy cases. So why does Simma mention that kind of stuff? Well, the threat which combines these cases is that they had to do with human rights. The court took the questions up, but then in the respective judgments or opinions, technical questions are dealt with, which have a much broader application than with regard to the human rights questions in point. And then, of course, you have a third group of cases in which the court developed the right to self-determination of peoples. Why do I mention self-determination in a presentation on the ICJ and human rights? Well, because you know that in the human rights doctrine of the United Nations, the realization of self-determination in the context of decolonization is regarded as the conditio sine qua non, as the condition for the enjoyment of individual human rights. So to just put it a bit more freely, without prior self-determination of these peoples, there can be no genuine, full-fledged individual human rights. And with the increase of decolonized, let's say, new member states of the United Nations with a colonial background, of course, the drive in the United Nations for also in the direction of the ICJ to deal with these matters became stronger and stronger. So you have already in the 1950s, you have a number of cases which had to do with the way and the possibilities for the United Nations to supervise the mandate system, which was still in force in South Africa and in Southwest Africa. I think you have three advisory opinions on the court on this matter, which of course on the ground did not help very much. Then you have the famous or infamous Southwest Africa case that I've just mentioned a few minutes ago. You have that, let's say, the attempt by the ICJ to free itself of that image. You have Barcelona traction, but then you have an opinion on the legal consequences for states of the continued presence of South Africa in Namibia, 1971, where the court said that, for instance, the gold and diamonds and the resources of Southwest Africa and Namibia are a property or belong to the people of Namibia and not to South Africa. And that has the consequence that if you Western countries, you engage in commerce with these, resources, you will be in trouble. You will be in trouble. And I think that opinion really had an impact on the further way that the question of South Africa developed. Then you have, I've just finished a number of cases, or mentioned a number of cases where on decolonization, you have the Western Sahara case, Western Sahara, in which the court more or less told the Spaniards that their dominance over the Western Sahara had come to an end, that the inhabitants, the indigenous population of the Western Sahara had a certain international legal personality. Then you have the East Timor case in 1995. You had the Portuguese moving out of their colonies in East Timor in the early 1970s. You had a liberation movement there, but before the liberation movement could establish its own state, Indonesia, as the regional, not superpower, but power, moved in, and you have decades of a fight against the regime by Indonesia. And a lot of crocodile tears being by Western countries. My God, Indonesia why are they there? They should go. But for instance, the United States being very happy about the relatively, reliable state of Indonesia dominant there instead of these proto-communists in the liberation movement. And in that situation, Australia concludes a treaty with Indonesia about the expropriation of the oil and gas in the so-called Timor Gap between Northern Australia and Indonesia. And that brings Portugal before the ICJ. And Portugal claims, among other things, that it is the responsible administering country. It is responsible for what happens there. And so there is Australia breached international law by engaging in that business with Indonesia. And the court, to the great disappointment of human rights lawyers, came out and said, well, there is something which we call the indispensable third party, which means I cannot find Australia in breach of international law before that also finding Indonesia in breach. And Indonesia has not accepted the jurisdiction of the court, and that is the end. Thank you very much, full stop. 1995. Great disappointment. Then you have the Wall opinion, in which where I already was on the court, the legal consequences of the establishment of a separation wall on the occupied Palestinian territories of 2004. You have the Kosovo advisory opinion in 2010. And the last one, the very recent one, on which I'm going to say just a little bit more, would be the opinion that was rendered last year on the legal consequences of the separation of the Chagos Archipelago from Mauritius, where the General Assembly asked the court to render an opinion on the question whether the process of decolonization of Mauritius was lawfully completed when Mauritius was granted independence in 1968. But before that, the so-called Chagos Archipelago, a number of islands in the Indian Oceans, had been separated from Mauritius and was kept under British, jurisdiction. And the second question was, what are the consequences of what happened there? And the court came out and said the process of decolonization of Mauritius was not completed in '68. There is still the problem there of granting of Great Britain just disappearing, moving out, and the Chagos Islands being able to, let's say, have their voice and more or less reunite with Mauritius. That was the idea. This is was a very strong opinion, a great success for the third world countries. For the it's also politically a very, very tricky one, because one of the islands in the Chagos Archipelago is an island. God, I can't think of the name, in which the United States, in which the United Kingdom granted the United States the right to establish a huge naval base. You find there warships, you find airplanes, you find nuclear weapons. Diego Garcia, which is one of these islands. And so, of course, if the ICJ says in an opinion, Great Britain, why don't you just disappear from there? That also means that the United States should probably disappear, is not an easy answer to, it's not an easy question to answer. And the reactions by the United Kingdom were, as you can imagine. Okay, so this is the first stage. Now I would suggest that we have a 5 minutes break. Okay, back to work. I now turn to to my next chapter, which is really getting to the core of my lecture. That is, we now have, or in more recent years, we have had cases in which the ICJ dealt more fully with human rights questions, and dealt with human rights questions in a more, let's say, at least in the majority of cases, in a let's say, satisfactory way. So let me just tell you what cases I'm talking about here. I think the first one in that row would be an advisory opinion again. So you will have noted that I also regard advisory opinion proceedings as cases in a non-technical sense. So this would be the case of the opinion on the legality of the use by a state of nuclear weapons in armed conflict, an opinion rendered in 1996. When I joined the court, I heard from my colleagues at the court who had been there at the time that no other case had seen so much actual fighting and fury than this case. Of course, you will know that the most interesting thing about the advisory opinion is that the court said it could not come to a conclusion as to whether the employment of nuclear weapons against an armed attack was a breach of international law, so very problematic. But the court also dealt with a number of the aspects of the case from a human rights viewpoint, namely from the viewpoint of a human right, international human right to life. But of course, it did not, the real decisive questions were use of force questions, actually. Now, the next case in point would be the Wall opinion. This was the first of the cases that I'm going to mention now, where I was a member of the court. Also a very political case. And one of the points that the court dealt with was whether the construction of that wall had also led to human rights violations. Of course, under the circumstances, mainly violations of the economic and social rights of the Palestinians there, which by the wall were separated from their, let's say, agricultural fields and olive trees, etc., etc. So another point in question was that the court developed a bit further this concept of obligations erga omnes and rights erga omnes in the Wall opinion. So quite a bit on human rights. The next step was the decision in 2005 in a case between Congo and Uganda. There was what we call the Great Lakes Wars in Africa from the late 1990s into the early 21st century. And the Congo, the Democratic Republic of Congo, brought cases against its neighboring states who had all been involved in armed conflict on the territory of Congo, which the Democratic Republic of Congo wanted them to get out of their territory. They didn't. So that was more or less the political situation. And in the Congo-Uganda case, the court found on the basis of reports by United Nations, commissions, investigations, that a lot of human rights violations and a lot of violations of international humanitarian law had occurred in that conflict between Uganda and the Congo. And this was the first case where, if you look at the dispositif, that actually the tenor of the judgment of the ICJ, you find for the first time in the history of the court that certain human rights, the courts find that certain human rights violations have occurred, that certain violations of international humanitarian law have occurred. So that, I think, is a step that needs some attention. Then after the Congo-Uganda case came a case against another neighbor of Congo, namely Rwanda, Congo-Rwanda, in which the court rendered a judgment in 2006. So there's really year after year now. And in the Congo-Rwanda case, the Congo complained or claimed that Rwanda had violated a whole range of multilateral treaties to which both it and Rwanda was a party. And one of these multilateral treaties was the convention, the Genocide Convention of 1948. But Rwanda had, when it signed up to the Genocide Convention, made a reservation excluding the jurisdiction of the court, which of course is remarkable. This happened after Rwanda had become the place where one of the most monstrous genocidal, let's say, acts had taken place since World War II. And this very country, Rwanda, excludes the jurisdiction of the ICJ to decide about such cases. But the court had already in earlier cases found that also reservations to the Genocide Conventions work like reservations do as they are desired to do by the reserving state, namely exclude the court from meddling in these instances. There had been a case involving no less than 10 NATO countries brought back by Serbia, and most of these NATO countries did not have to appear before the ICJ because they had made reservations on how does the Genocide Convention come into a case between NATO and Serbia. Well, Serbia claimed that some of the ammunition which was used by NATO airplanes in their attacks on Serbia had an element of depleted uranium. I don't know what the effect of that is. It's not that by using that kind of ammunition, the states intend to employ, let's say, something nuclear. It's just that the depleted uranium has a certain effect, that increasing the effectiveness of the weapon. And so Serbia said, we have in our soil now, due to your attacks, depleted uranium, which is going to be a health problem for generations, and that is a violation of the Genocide Convention. Well, with regard, but the court did not really speak out about that question because of the reservations that had been made in that regard. And then came Congo-Rwanda, and the court said, well, we have to stick to our jurisprudence. You cannot conclude that if a treaty is as important, as fundamental under human rights terms, like the Genocide Convention, no reservations, including our jurisdiction, can be made. That would be desirable, maybe, but that is not how the law of reservations works. So Rwanda, let's say, Rwandan behavior cannot be looked at from the viewpoint of the Genocide Convention. This was very, very unsatisfactory to a number of members of the ICJ, among them myself, but also Judge Higgins, Judge Owada, Judge El Arabi. And so we issued a joint dissenting opinion. I think 5 judges issued a joint dissenting opinion in which we said, listen, the Genocide Convention is also a human rights convention. Of course, a very fundamental human rights convention. Now, all other more modern human rights conventions have at least treaty bodies sitting on them, and these treaty bodies will look into the question of violations. There will be a dialogue. There will be some kind of, let's say, not judicial activity, but at least some method to find out whether genocide has occurred or not. In the case of the Genocide Convention, the only treaty body, quote unquote, that you can find is the ICJ itself. So if you exclude the jurisdiction of the ICJ, that means you kind of take away from that treaty the only let's say tooth, that the only weapon that treaty really carries. And then, of course, this case, Congo-Rwanda, took place at a time when both the Soviet Union and all the other former communist countries of Middle and Eastern Europe had revoked their reservations to the Genocide Convention. So we said this is ahistorical, and that has to be changed. But of course, reservations being made stay there, and as far as I know, none of the countries in question had revoked their reservation to the Genocide Convention. So Congo, Rwanda. And then come the big genocide cases against, first against Serbia, Montenegro. The first one brought already in 1993 against Serbia by Bosnia-Herzegovina, and the second brought by later brought by Croatia against Serbia. Let me say a few words about the first, Bosnia-Herzegovina against Serbia on genocide. I think that was a case in which Bosnia-Herzegovina really pursued a wrong tactics before the court. Well, maybe I should go a bit. I don't know how close you are in your memories with regard to the war in Yugoslavia, but that was a war in which Bosnia-Herzegovina had declared its independence, and that immediately led to Serbian forces invading Bosnia-Herzegovina, and later on the so-called Republika Srpska, that is the Serbian part of the population of Bosnia-Herzegovina, declaring its own state, having its own armed forces, and engaging in violence within Bosnia-Herzegovina. And so the question was, now what is this? Is this an international war, or is it a civil war within Bosnia-Herzegovina? And the UN and the International Criminal Court for Yugoslavia in The Hague regarded this as an international armed conflict. And of course, if there's an international armed conflict, you can apply much more effective IHL, international humanitarian law, than in case of a civil war. And so that was how Bosnia-Herzegovina looked at things. They said, what you see from Republika Srpska and Serbia is one huge violent act of genocide against us, one activity of genocide. The ICTY came to another conclusion. The ICTY came to a conclusion that there had only been one instance of genocide, namely in 1995 in Srebrenica. And you probably have seen on television, etc., that a few days ago there was the Memorial Day on Srebrenica. That is one genocide. And so the question for us at the ICJ was, this is a case that is brought against Serbia. So what did Serbia have to do with that Srebrenica genocidal activity? And the court came to the conclusion that, of course, the case could not be brought against Republika Srpska itself, but against Serbia. And Serbia's involvement was so that the regime in Serbia, in Belgrade, that Milosevic had not sufficiently tried to prevent that genocide from happening, had not engaged sufficient, let's say, power or influence on Mladic and Karadzic, the political and military heads of Republika Srpska, not to engage in these massacres at Srebrenica. So it was not found of a let's say, a violator. It was not found to be an accomplice. It was only found to be in breach of, it had not applied enough due diligence to prevent. So that was about I'd say, the most lenient way for the ICJ to bring Serbia into the picture. In my view, it was an appropriate way. And I can tell you, it is not an easy thing for an international court based on consent to its jurisdiction, all that, to declare that a certain state party to its statute has committed genocide, which is, of course, the most, let's say, condemning judgment that an international court could really render about the country. And we'll get to the current case on that in that matter in a second. So I think that was 2007, the Genocide Convention decision. Of course, the decisive problem with genocide is it's not enough for genocide to engage in, let's say, huge massacres. What makes a crime against humanity, a massive human rights violation or IHL violation, a breach of the Genocide Convention, is that if in massacring these 7,000 people at Srebrenica, you have a special intent, a so-called dolus specialis, which means to kind of annihilate the group, And in this Yugoslavia case, what the court said, what happened was ethnic cleansing. And of course, ethnic cleansing by terrorizing the population so they would move and probably go to Germany and leave the country to the Serbs there. But ethnic cleansing is not something pursued with that special intent to annihilate the group. You just wanted to move away, to move to some other place. And that was also the problem with the other Genocide Convention case that Croatia brought against Serbia, which had to do with the armed activities and violations of IHL committed by the Serbs in what would be northern Croatia, where also massacres had taken place, etc. But the court came out and said, unfortunately, it is not possible for us to determine that there was this dolus eventualis there. It was huge crimes were committed, terrible things were committed. And of course, behind that was hatred and more ethnic conflicts dating back to old times, etc., but not the intent to, let's say, get rid of an entire group of the population. Okay, Genocide Convention. Croatia against Serbia was actually decided in I think it was in the 2013 or 2014, around that time. Okay, right. Now that gets me, and I have to close the door because my family has arrived here. Just a second. If I don't lock the door, one of our grandchildren will come and more or less change the subject. So I now come to the core human rights cases since 2010. And the first one there is a case which is a little strange. It's the so-called Diallo case. This Diallo was a Guinean businessman who had invested again in the Democratic Republic of the Congo, the DRC. And he didn't fare well there. He lost his property and he ended up in prison. And then at the end, he was evicted from the country. And so Guinea, his home state, brought a case before the ICJ, which is strange because I remember already at the time, I thought, isn't that a case that would fit an investment tribunal, and where investors can sue countries in which they have made investments, and these investments are then taken away, or no fair and equitable treatment was used against them, etc., etc. And actually, it was a case actually built, but for some reason, Guinea decided to bring it before the ICJ. And in the ICJ, there was a first phase. At the end of that first phase, all the international economic aspects of the case, that is, how was the property? It was mainly container stuff. How was the property treated there? That is not our business, said the court. We don't have jurisdiction. And from then on, the Diallo case was a pure human rights case. And the questions before the court were, did the Congo breach the International Covenant on Civil and Political Rights and other human rights conventions by putting Diallo in prison, by keeping him in prison, by not feeding him adequately in prison, etc., etc. That it would be conditions of detention and arrest, and then the expulsion of an alien. So those were the human rights questions that the court then decided in its judgment. The judgment was rendered in 2010, and what I find interesting about it is that the case would strike you as familiar, namely, isn't it a case of diplomatic protection where the home state of Diallo, Guinea, engages in protecting the victim of human rights violations in another country, a victim of its own nationality, namely Mr. Diallo? Yes, indeed. And of course, nothing is in the way of diplomatic protection. Is still a very important institution, and nothing is in the way of engaging in diplomatic protection by going before the ICJ, right? But then, of course, when we talk about diplomatic protection, you will remember the Mavrommatis case, that is the basic case on diplomatic protection, in which the Permanent Court of International Justice had said in the 1920s already, diplomatic protection takes place when a state acts in favor of one of its nationals, but thereby protects its own rights, namely the right of the home state not to be violated in its right by what happens to its national. That is, Mr. Diallo, under that paradigm, would not be the real victim. The real victim would be Guinea, and Diallo would simply be the means by which Congo violated the rights of Guinea. And the ICJ, in its judgment, really dissects the case from the Mavrommatis. It deals with the human rights violations of the person of Mr. Diallo, and not translates this into a violation of some state-to-state rights. And the only little remnant of the Mavrommatis thinking comes out at the end when they speak of reparation. So that was after I had left the court. They said, what had Mr. Diallo, what had he lost, etc. They came up with a very modest sum compared to the sums that I deal with when I preside one of my investment cases. They're less than $100,000. And then the court says, this money goes to Guinea, but would Guinea please keep in mind that Mr. Diallo was the one who suffered that injury? In other words, just hand the money to Mr. Diallo. And I hope very much that's that's where he got that money actually. So the interesting thing is that in the Diallo case, the court looked at the human rights and engaged in a determination of breaches of the human rights of an individual, not through that fiction of Mavromatis. And another thing which is interesting is that was the first case in which the court also mentioned or referred to decisions of UN human rights treaty bodies, and I think even of the European Court of Human Rights, which is very interesting. And because the court, when you look at the judgments of the court, you see that the court is very, very selective in what he quotes, in what the court refers to and quotes with regard to cases. I remember once, and that will lead me to the end of my class today. I remember that I was in the drafting committee in another case, and I come up and said, I found a very interesting case of the ICTY that we could use here. And then the registrar looked at me and said, well, Mr. Simma, you know, we never quote other international courts, which has to do with that self-perception that we are the highest. And so we don't have to refer to these lowly creatures, ICTY, and so on and so on. But in Diallo, that limitation was broken. And of course, that was a consequence of the genocide case, because in the genocide case, one weakness of the ICJ was, of course, shown in great clarity, namely that the ICJ has no independent fact-finding capacity at all. Fact-finding by the ICJ is something, the ICJ sits there and it relies more or less on what the parties put before it. And with regard to the genocide, that was, of course, a special problem. But in the genocide cases, what you had was the jurisprudence of the International Tribunal for the crimes committed in Yugoslavia. And while when you look at the court's judgment in the genocide case, you see the court behaves as if it had engaged in fact-finding. But what it does, it really refers to and relies on what the ICTY had found. Good. I think I stop here. I have 2 or 3 minutes to go. Well, maybe I can, I just deal with one more case. So, Diallo was a very promising case, you know. And then came a case which was decided in 2011, which really disappointed me severely. And that was a case brought by Georgia against Russia. Georgia in 2008 became the theater of an armed conflict with Russian troops moving into Georgia, and parts of Georgia having already been occupied and more or less detached from its territory by violence by Russia. And that led to claims brought by Georgia against to the European Court of Human Rights and also to the ICJ. And Georgia claimed violations of the International Convention against all kinds of racial discrimination, because said Russia had more or less displaced persons of Georgian nationality in favor of Russians, etc., etc. It was a bit of I think the link that led to the jurisdiction of the ICJ was a very weak link, actually. But the court grabbed it. The court rendered provisional measures in October of 2008 that were regarded to both countries and said desists from these activities. But a few years later, the court came to a negative conclusion about the jurisdiction, because it said, when you look at the third convention against racial discrimination, you see that the way to the court is only open when a state has made a sufficient attempt at engaging in a peaceful solution by negotiation. And that has not been, that Georgia was not able to show in the court majority's view, which I did not share. So I wrote a long separate opinion and joined a dissenting opinion, and the Georgia v. Russia case is still the court that I like least of all the cases I had at the ICJ. That gets me to the end. Tomorrow I'm going to continue with a more let's say, promising, and cases like Belgium against Senegal, and also the Myanmar case, etc., etc. So I hope that will keep you interested in what I have to say. And for today, it's obrigado. And I'll see you again tomorrow.
Thank you, Professor Bruno Simma, for showing us at the beginning 3 groups of relevant cases in which human rights considerations occupied somewhat more space in the jurisprudence of the ICJ, or in which the court developed the right of self-determination of peoples. It's very important. Also, Professor Simma showed us that at least in the last few years, the ICJ has turned to decide cases focusing on human rights violations, at least allegations of human rights violations. And this review of the court's jurisprudence is very important, has shown a growth in the number of human rights related cases. And I think that everyone here, we are expecting more tomorrow. I'm grateful, Professor Simma, for this instigating lecture, which will certainly generate much reflection for the students who are seeing us. Dear colleagues, dear students, finally we come to the end of the first part of the lecture. We will leave the questions for tomorrow. Thank you all for your attention. Bye.
Okay, thank you.